Well, hello everyone, and welcome to our COVID-19 U.S. Stimulus Business Provisions and Essential Business Designations webinar. My name is Chris Marty, and I'm the Vice President of Data Analytics and Executive Education at MSCI. Before we get started, I'd like to go over a couple of housekeeping items, just so that you know how to participate in today's event. What you're seeing here is a slide that shows you the GoToWebinar interface. You will all, as attendees, remain muted during the duration of this webinar. That's so that we can reduce all the background noise. You're listening in on your computer speaker by default. If you have trouble with that, you can switch over to a phone call, and that works pretty seamlessly through the GoToWebinar interface. You'll have an opportunity during the webinar to submit text questions to the presenters by typing your questions into the questions pane of the control panel that you see on the screen. You may send your requests and questions at any time during the presentation. We'll collect those and address them during the Q&A session at the end of the presentation. As you know, federal policymakers in the United States have now passed 3 major spending bills related to the COVID-19 pandemic. Executive branch agencies are still in the process of developing guidance on all of the provisions of those laws. That's what our webinar today is about. I'd now like to introduce our 2 guest speakers from the U.S. Chamber of Commerce. First, Glenn Spencer, who is the Senior Vice President of Employment Policy Division, and Glenn will talk to us about the provisions and implementations of the CARE Act and the Family First Coronavirus Response Act, and provide an overview of the aid available to small and large businesses. Then joining us is John Drake, Executive Director, Supply Chain Policy, who will discuss the U.S. Department of Homeland Security's guidance on essential business designations, how states are using this guidance, and how the industry can expect this guidance to shift over the coming weeks. So Glenn and John, welcome. Thank you for doing this webinar, and I'm going to turn the presentation over to you to get started.
Great. Well, thank you, Chris, and I appreciate the opportunity to be on the call with all of you today. Typically, I prefer to do presentations like this live, but I suspect if we were doing this presentation live as opposed to via webcast, we'd be talking about an entirely different subject. Like the rest of the U.S. Chamber staff, John and I are working remotely from home, and so that poses some unique challenges, but I think due to the technology we've got available, we'll get through all that. This is obviously an unprecedented time nationally and also in Washington, D.C. Congress is not in the habit of passing 800 to 900 page bills in less than a week, and so the result of that is that there's a lot of drafting issues where things are not 100% clear. The agencies are starting to issue guidance to help us navigate through that. We don't have all the answers just yet. We do have a lot of them, but we don't have all of them. So there may be times on this call where John or myself or both, we don't know. And we'll just have to tell you, we don't know the answer to that yet, but we are working to try and get all those answers. So what I'm going to cover is the provisions in the CARES Act and then some of what was in what's being called FICRA, the Families First Corona Response Act. The easy way to navigate or to talk about these bills is to refer to them in phases. You'll hear a lot of people in DC talking about phase 2, phase 3. All they're referring to is the number of Corona bills that have passed. So phase 1 was the roughly $8 billion package that the president signed into law probably a month ago. The phase 2 bill, that's the bill that was signed about 2 weeks ago, roughly $100 billion in that bill. And then phase 3 is this big stimulus bill that was just signed last week, the CARES Act, which includes about $2 trillion in spending of one sort or another. So we can go ahead and move to the next slide. So some of the major provisions in this bill, it talks about money going to the Federal Reserve, amongst other things. So because of the way the Federal Reserve takes money and then leverages it into additional lending facilities, the estimate is that what was in the CARES Act will result not just in the $2 trillion you see in the headline number, but an additional $4 trillion in support of the economy based on how the Federal Reserve will leverage the money that this bill provided to it. The bill also includes automatic payments to individual taxpayers. So that's $1,200 per individual, $2,400 if you file a joint return, and another $500 on top of that. This is money that the Treasury is simply sending to individual taxpayers. Whether you're working or not, you're getting this money into your account depending on your income. So it does start to phase out for incomes above $75,000 or $150,000 if you file jointly. CARES Act also includes a significant expansion of unemployment benefits. So some of the restrictions around eligibility are being loosened if your inability to work is related to COVID-19. There's an additional $600 per week on top of whatever regular state benefits an individual might receive. That $600 per week expires on July 31st. So that is not a permanent thing or even a long-term thing. It's only for the next several months. The eligibility for UI, as it has in the past, ends if an individual can return to work or they get offered a job. All of those expanded UI benefits are going to be provided through state UI offices. So if you've got workers you need to advise about UI questions, the expanded benefits under this bill are going to be available, as they always are, through your state UI offices. You don't need to do anything through DC for that. If we can go ahead and move on to the next slide. Okay, so some major provisions for employers. So every employer is going to be impacted by some of the tax changes, as well as the employee retention tax credit. For larger employers, there are some specific loan programs, loan guarantees. As I mentioned, these Federal Reserve credit facilities that larger employers will be able to tap into. For small businesses, there's something called the Paycheck Protection Program, and we'll talk about that in greater detail in a minute. There are SBA Economic Injury Disaster Loans, what they call EIDL loans. But then there's also paid and sick FMLA leave, which smaller businesses will have to deal with. And we'll talk about all that in just a second, too. We can go on to the next slide. Okay, so for all employers, these tax provisions apply to you, whether you've got 5 people or 5,000. You can delay payment of your employer payroll taxes, okay, primarily Social Security, between now and January 1st of 2021. So you can just hold on to that money, use it for what you need to. Of course, that doesn't mean you can just not pay it. You will have to pay that money eventually. So half of whatever you hang on to will be due at the end of 2021, and then the remaining half due at the end of 2022. So this simply allows you to push those payments into the future so you can use cash now. Now, this does not apply to any employers who've taken or had their loans forgiven under Paycheck Protection Program, which again, we'll talk about that in just a minute. Some other tax changes that apply to everybody. You can carry back net operating losses for 5 years. You can suspend the 80% limitation, and this extends to pass-throughs and sole proprietors. You can also accelerate recovery of your AMT credits. In addition, you can increase the limit on interest deductibility to 50% for years 19 and 20. They've also fixed the qualified improvement property issue. Some of you may have run into that, where in the previous tax law that was signed a couple years ago, they had forgotten to allow people to use accelerated depreciation for qualified improvements to property. That has been fixed. We can go on to the next slide. Okay, the employee retention credit. That is also going to apply to all employers. So the idea behind this is they want people to keep workers on their payroll even if those workers aren't actually doing anything. The whole logic behind that is when we do get through to the other side of this, you need to fire up your businesses again. You don't have to go out and recruit and train an entire new workforce. You've already got these people on your payroll and you kept them there. And one of the ways they want people to do this, or they're encouraging people to do this, is through the employee retention tax credit. So if you see a drop in revenues, gross receipts, in a calendar quarter that drops by 50% or more compared to the prior year's quarter, you can then be eligible for this employee retention tax credit. So it's a refundable tax credit for 50% of the wages that you pay to an employee, up to $10,000 per employee. So it's a refundable tax credit per employee. If you've got more than 100 employees, the tax credit only applies to those workers who are not actually providing you with any services. And remember, this is to keep those people on your payroll, even if they aren't actually working. If you've got fewer than 100 employees, you can take the tax credit on all of your employees, those who are working for you and those who might not be. It's good for everybody there. Again, you cannot take this tax credit if you're getting a loan under the Paycheck Protection Program. That's to avoid anybody double dipping. And we'll talk about Paycheck Protection again in a second. And there is, the Treasury is trying to create a mechanism to allow for advance payment of that tax credit as well. If we can go ahead on to the next slide. Okay, for the mid-sized and larger employers, this is where you get those loans and loan guarantees, and then the Federal Reserve Credit Facility. So the CARES Act provided $454 billion to the Treasury Department to make these various loans and loan guarantees. A big chunk of that, as I said, has gone to the Federal Reserve. That is leveraged for even more support for the economy. There are special programs for the airline industry, also for industries deemed to be critical national security businesses. But this money comes with some strings. There's going to be restrictions on stock buybacks, limits on executive compensation. But overall, we're going to see a lot more of these types of credit facilities that the Federal Reserve will set up. So a lot of money will be flowing through this spigot. If we can move on to the next slide. Okay, for the smaller businesses, self-employed, independent contractors, nonprofits, there's something called the Paycheck Protection Program. This is money that has been set aside for the SBA. Roughly $350 billion in loans will be available through this program. That's going to be for employers who have fewer than 500 employees for the most part. 501c3s are eligible. Self-employed, sole proprietors, ICs, they are all eligible for this as well. So there's a formula for these loans so that it's the lesser of 2.5 times your average payroll, right? 2.5 months of your average payroll, or up to $10 million. The SBA website has some guidance on how to make that calculation. These loans are not going to be provided through the SBA directly. These loans are made by local and national lenders. So if you've got a bank that you typically work with and they are an approved SBA lender, that's where you would go to get these loans. Other banks are now signing up to be able to provide these loans. There's a little bit of a delay with some of that. Banks who aren't already affiliated with the SBA lending programs are trying to figure out how to make all that work. Even some banks that are affiliated with the SBA are taking a little bit of time to figure this out, but that money is starting to flow. And if you look, for example, at the Wall Street Journal today, there's some statistics about how much of that money is now starting to get out on the street. So it is moving. If you're interested in one of these loans, you should talk to your lender and see if they are an SBA approved facility. And if they're not, are they looking to become one? Because that's where this money comes from. You don't get this by going directly to the SBA. They're reducing the requirements to get approval for these loans. They're trying to make these move very, very quickly, so there's no collateral, no personal guarantee. And this is the key, this next bullet, that these loans can convert to grants equal to an amount that you spend on payroll, rent, interest on a mortgage, or utilities for the next 8 weeks after the loan origination date. So whenever that loan gets approved, you've got 8 weeks then. And if you use all of that money for those specified purposes, essentially it becomes a grant, it's loan forgiveness, so you don't actually have to pay the money back. And again, the whole idea here is to encourage employers to keep people on their payroll, even if those people aren't actually doing anything. They just want you to maintain that connection with your workforce so you can get back up and running as quickly as possible. Now, the loan forgiveness can be reduced, so if you reduce the number of your employees on payroll, that will result in a proportional reduction in loan forgiveness. Similar to that, if you reduce wages paid to those employees by more than 25%, your loan forgiveness will be reduced proportionally. Let's say you've already laid some individuals off. You can still get one of these loans and still get loan forgiveness if you bring those employees back on payroll and restore their wages within 30 days and you maintain them through June 30th. So just because you may have laid somebody off already, you can still get one of these loans and you can still get loan forgiveness. Can we move to the next slide? As you'll see here, we've got a little brochure available at uschamber.com/SB Loans that explains hopefully with some more clarity than I might have provided, how you go about applying for these loans, what some of the issues are around it. So I'd encourage you to go to that site if you are interested in one of these SBA loans. Go ahead to the next slide. Okay, let's talk about these EIDL loans, the SBA Economic Injury Disaster Loans. These are available for small businesses, again, nonprofits, including C6s and other groups, sole proprietors, independent contractors, basically any business with fewer than 500 employees. These loans provide up to $2 million in working capital on a 30-year term. Low interest rates, your payments can be deferred up to a year. These loans are based on your credit scores. There's no tax returns required. Key to this program is getting money out on the streets fast. So up to $200,000 can be given without a personal guarantee. If you're taking a loan of less than $25,000, there's no collateral required. If you need cash urgently, they are actually providing $10,000 emergency grants within 3 days, and that money does not have to be repaid. Now, the way this interacts with the Paycheck Protection Program is, let's say you can apply for both loans. If you have an EIDL loan, you can actually convert that over to a Paycheck Protection loan and then see if you can get loan forgiveness under that program. So the two programs do interact. Unlike the Paycheck Protection Program loans, these EIDL loans are through the SBA. So you actually apply on the SBA website. There's a simple application form that you fill out, and then that will start the loan approval process. So small business or Paycheck Protection loans, that's going to be through your local lenders. These EIDL loans, that's going to be through the SBA website where you do the application. If we can go ahead and move to the next slide. All right, paid sick leave. This is actually from the Phase 2 bill. Two key numbers to remember here are 50 and 500. So if you have more than 500 employees, you don't need to provide paid sick leave under the Phase 2 bill. If you have fewer than 500 employees, you do. However, if you have fewer than 50 employees, you may, I repeat, may be able to get an exemption. It is not guaranteed, but an exemption might be available if you're under 50 employees. So let's assume you're in that range where you're going to have to provide paid leave. Under the bill, you have to provide up to 10 days of paid sick leave if that leave is related to the coronavirus. So an employee can take that leave if they are sick with the virus itself, if they've been quarantined because a healthcare professional has told them to do so, if they need to take care of a sick or quarantined family member, or if they need to take care of a child because that child's school is closed or their regular caregiver is not available. All of those reasons will qualify an employee to take that paid sick leave. Now, the rate of pay is going to be at the employee's regular rate of whatever you pay them, up to a maximum of $511 per day if they're taking care of themselves. If they've been quarantined, if they're sick, they're going to see a doctor, that's the $511 per day maximum. If they are taking time off to care for a child or a family member, it's 2/3 their regular rate of pay, up to a maximum of $200 per day. So you're not going to pay more than $2,000 in total if they're taking leave to care for a family member or a child. These payments that you make for paid sick leave are 100% reimbursed by the federal government. That's going to be through a refundable tax credit. Treasury is endeavoring to get that money out quickly to individual firms that need it. In fact, what they have said in some guidance is if you are making payments to employees for paid sick leave, just hold on to whatever payroll taxes you were going to set aside. You use the money to make those payments. Then at the end of the quarter, we'll settle up. If we owe you more money, we'll give you more money. If you owe us some money, we're not going to penalize you because you withheld that money from us in anticipation of getting a tax credit. So they're trying to get that money out to employers as quickly as they can. Key point about this leave is that this is in addition to any other leave that you already provide, including state or local leave requirements. So if you're in DC, like the Chamber is, we're required by law to provide 2 weeks of paid sick leave. The leave under this Phase 2 bill is in addition to that. So essentially we would have to provide up to 4 weeks of paid sick leave. but the portion that the federal government is requiring you to provide, that is 100% reimbursable. So in theory, your costs net out at zero for that. Now the exemption, if you have fewer than 50 employees, you might be exempt if you can demonstrate that giving someone leave, well, actually, let me back up a second. The only way you're exempt is if a person is taking that leave to care for a child because their school is closed. Okay, if they're taking it because they're actually sick, no exemption. If they're taking that leave because their kid's school is closed, you might be able to get the exemption. You go then to phase 2 of the analysis, which is, would providing that leave threaten the viability of my business? And there's some very specific conditions the Department of Labor has laid out to what that means. If you go to the Department of Labor's Wage and Hour Division, they've got a long series of Q&As about this provision. I think it's questions 57 and 58 spell out the criteria for what the small business exemption actually means. Another key fact about this paid sick leave is not available if an employee can telework. So somebody who is sick, they need to stay home. If they can still perform their job remotely, they are not eligible for paid sick leave. If we move on to the next slide. Okay, paid family leave. This is a little bit similar to the paid sick leave. Key number is 550. So if you've got more than 500 employees, no obligation to provide this paid sick leave. If you've got fewer, it does apply to you. If you have fewer than 50, you, again, may get an exemption. So under this provision, you have to provide, it looks like there's a typo on this slide. It says 10 days. Oh, sorry, hold on. I'm on the wrong slide myself. Yeah, so you have to provide up to 10 weeks of paid FMLA leave if an employee needs to take care of a child due to a school closure or the regular child care provider is not available. So unlike the sick leave, which has all those different reasons, the only reason someone can take paid family leave here is to take care of a child because their school is closed or the child care provider is not available. This leave is going to be paid at 2/3 the regular rate of pay, up to a maximum of $200 per day, total of $10,000 in the aggregate. If somebody took all the 10 weeks of paid leave, that would be $10,000. Again, this is in addition to any other leave you might already provide or are required to provide under state or local law. Just like sick leave, this leave is going to be reimbursed by the federal government through a refundable tax credit. And the same exemption applies for fewer than 50 if someone is taking care of a child because their school is closed or their caregiver is not available. And you can show that them taking that leave threatens the viability of your business as a going concern, you may be eligible for the exemption. And again, paid leave not available if someone is able to telework. That's my portion of it. I'm happy to turn it back over to John.
Great. Thank you, Glenn. So I am going to talk a little bit about the federal guidance that's coming out of the Department of Homeland Security's Cybersecurity Infrastructure Security Administration, and also kind of give an overview of why that guidance is important in the face of the increasing number of state quarantine orders that have been issued by the governors over the last few weeks. If I may, going back to late March, as the coronavirus was gathering more and more of the public's attention, and also there was increasingly recognition that for public health purposes, that there would have to be some form of quarantine orders that were issued. In late March, the states of California and Pennsylvania issued quarantine orders. And those two states issued very different quarantine orders. Pennsylvania, by and large, with its first draft that went out, established a quarantine order that basically shut down any, basically 99% of all businesses and all services, except to allow for businesses and applicants to apply to the governor for a waiver from that quarantine. In California, they went a little bit more organizationally in that they issued a quarantine order that identified key industries and services that could remain open during the quarantine. And what they did in issuing that, in identifying those essential services, was referenced back to the DHS's CISA's Essential Infrastructure and Employees Guidance. And for us, this was a really important development because our concern at the chamber level was because the quarantine orders and the public health orders that were being issued at the state and local levels were all being generated at the state level. We wanted to make sure that there was as much uniformity throughout all of these quarantine orders as possible. We knew that without it, that each governor could issue his or her own quarantine order, recognizing certain sectors of the economy as being essential and therefore being exempt from a quarantine order, and some governors essentially not doing the same thing. So our concern here was that you could have certain sectors of the economy that would be recognized as essential in some states and not essential in other states. And this would create just an impossible patchwork of regulations and operational challenges for businesses that didn't operate just in one state, but also could potentially operate all across the country, because of the supply chains would have suppliers that would be potentially under certain quarantine orders and others that wouldn't be under other quarantine orders. So we were very happy with what California did in issuing its quarantine order that referenced this CISA guidance. It was valuable for us because it put forth a federal standard of what was deemed essential and what was not. It wasn't politicized in the sense that you had a special interest group or other organization trying to basically champion their own industry or their own company. Instead, the federal government had something that had been vetted, that had been reviewed all across the federal government, and therefore really kind of took away a lot of politicization that might result if you had a similar list that was issued by, a trade association or some other group. And the last part about this too was that because it was vetted, we knew that it was going to have credibility, and for governors could then issue their own quarantine orders referencing this guidance, and there'd be a certain level of understanding about what that meant applied to, that you wouldn't have to contest over and over again at each state level. So as of today, there are approximately, I think all 50 states, including the territories of the United States and the District of Columbia, have all issued their own quarantine order of some sort or a stay-at-home order of some sort. Of those quarantine or stay-at-home orders, more than 20 have recognized the CISA guidance in some form or manner, either explicitly in the text of the quarantine order or in guidance that was issued alongside the quarantine order, providing instructions on how to what was covered and how to apply the quarantine order for the population at risk. And I think what's also been helpful about this CISA guidance is DHS has been open to feedback and input from the public. So, for example, when CISA issued this guidance in March, it covered a very wide spectrum of critical services, including utilities, police, health, delivery services, logistic providers, certain aspects of the financial services, banking, certain critical retail functions, some construction as it related to national security issues, on and on. And but we knew at that point that was not going to be comprehensive of every essential service that was going to be out there. And so what the chamber did was we advocated before CISA that they continue the conversation, they continue listening to public stakeholders. We are also advocating to the states and the state governors that in addition to incorporating the CISA guidance, that the governors also listen to what their publics or what their constituents were saying as well, in terms of additional critical employees that should be also captured in quarantine order. And so what we were happy is that approximately a week and a half ago, CISA revised its guidance. They issued what we're calling guidance 2.0 that increased the number of essential services and employees and businesses that were that are captured under that guidance. So that now I think it's quite a bit more comprehensive than what was originally issued. And because it's CISA that issued it, that means that every quarantine order was automatically updated to capture that new guidance, as opposed to each state having to kind of revise its quarantine order to add more essential guidance, more essential employees to their own quarantine orders. So by the fact that they're referencing the federal standards or the federal models, just makes the entire process of kind of continuing to sort of evolve of what's happening on the ground that much easier. So what the Chamber's doing now is I think we're continuing those conversations with CISA. I think they have communicated an openness to continuing hearing from stakeholders, from impacted stakeholders, and making adjustments to the guidance, especially as this continues to evolve. Depending on how long this closure lasts, there may be, I think, demands, or there may be expectations that guidance evolve in face of the changing situation on the ground. But we're also, I think, continuing that conversation with what's happening at the state level in making sure that in these quarantine orders that are being issued, not only are the states recognizing the CISA guidance and they're aware of the guidance, but they're also making sure that there's consistent application of these orders across the board. So, one, making sure that I think we've been pushing the National Governors Association, as well as various state governors and the legislatures, to issue either certificates or some sort of guidance that'll help local law enforcement officials and safety officials understand who and who is not called out under these quarantine orders and who is considered essential for the purposes of being preempted from these orders. And the other thing is, I think, also helping to make sure that there's clear lines of communication happening at the local level between the governors and businesses, to make sure that there's clear guidance coming from the governor that allows certain businesses to go forward, i.e., so that there's no confusion and that there's no delay in opening businesses that are deemed essential simply because the workforce may be uncomfortable or they may not understand that they're deemed essential, or there may be some question at the state government level as to whether or not business X is deemed essential for the purpose of the quarantine order. So that's been this conversation has really kind of shifted to a state-by-state implementation level. And then the other part of this conversation, where this conversation is now, is that a lot of these quarantine orders were issued in late March, or mid to late March, and they had deadlines on them. And so a lot of these quarantine orders are going to be coming up for review this week and next week. And so we're making sure that there's, where a certain state has a quarantine order that's in place, that we feel captures a significant portion of businesses that need to stay operating during this time, that the governor doesn't look to pull that back at all or to make changes that would upset that balance. And I think that's going to be continuing, I think, for a while now. And so with that, I think I've given a brief overview. I'll turn it back over to Chris.
Okay, thank you. Thanks to both of you for your presentations. Just so everyone is aware, John did not have any slides, so it's not a mistake that we haven't advanced the slides yet. Just getting a couple of questions about that. But gentlemen, we do have a lot of questions. So I'm just going to dive in here. Question that comes up first is regarding the PPP. When do you take your initial head count for your FTEs? Is it at the beginning of the process? What if we've laid off employees, but we haven't applied for the program? How does that work?
So I think the way this will work is you take your head count based on that. I don't want to give false information. I think the way it works is that you take your head count at the time you apply for the loan, but if you have already laid off employees, you can bring them back. And then if you keep them on payroll, you can qualify for the loan forgiveness. But Chris, if you can make a record, maybe of some points we need to clarify for folks. I don't want to give anyone the wrong information, so I can get you the full details on when you take that head count.
We'll save the questions, and you guys can weigh in on details as you know them later, if that helps.
Yeah, but so to the second part of that question, though, yeah, if you've already laid somebody off, you bring them back on payroll within 30 days, and then you keep them there through June 30th. That will count towards the loan forgiveness.
Okay. Second question, can a U.S. foreign-owned small business qualify for the PPP considering the foreign controlling entity is a large corporation?
This program is going to be for U.S. employees. So even though you might be based overseas, if you have U.S. employees, those workers that are here in the United States would be eligible for forgiveness under the PPP. But let's say you're a company based here, you have workers overseas, any payroll costs for those overseas workers not going to qualify for loan forgiveness.
Okay, so our next question is about the phase 2 bill, which I think took effect April 1st or 2nd. But we have 30 days to put into effect. Are the benefits retroactive to the 1st of April or not?
Yeah, those benefits are available starting April 1st. What the department has said is they are giving employers a little bit of a grace period to come into compliance. But let's say you were supposed to give somebody leave starting on April 2nd and you didn't. It doesn't mean you can just forget about it. It means you've got a limited window to go ahead and make the payments you should have made, and the department will not enforce that. In other words, they won't crack down on you for not having done it, as long as you are making a good faith effort to comply. But the actual availability of those benefits started on April 1st.
Okay, thank you. Next question. Are automakers considered essential per the most recent U.S. Department of Homeland Security CISA guidance on critical infrastructure workers?
So some aspects of their operations are. And what I can do is at the end of this call, I'll send a link around to you, as well as a tracker that the U.S. Chamber has developed that lists each quarantine order and where it does and does not reference the CISA guidance. But just to circle back on the question specifically, some aspects are, some aspects are not. And a lot of it's tied to if there's a national security implication to that manufacturing aspect.
Okay, thanks. Next question. For the payroll protection loan, is wage cost defined as only base compensation, or should bonuses be included?
It is based on the regular compensation you pay up to $100,000. So amounts, whatever payments you make to the employee below that amount are included, but anything above that $100,000 cap is not going to be counted for loan forgiveness purposes.
Okay, thank you. Another question. If we enabled our whole workforce to telework, does this mean our employees can't take advantage of the FMLA changes?
That's correct. If your employees are able to telework, and it's not necessarily if you just offered it. For example, if I offered telework options for all the waiters at my restaurant that I just closed, like that's not a realistic use of telework. But for like us at the U.S. Chamber, for any accounting, any of those types of jobs that you can do offline, or not offline but off-site, if that is an option for employees, then that they are not going to be eligible for paid sick or family leave. And it doesn't mean that you have to have had telework policies in place prior to this. It just means when they request leave, if you can realistically say, yep, this employee is eligible to telework and realistically can telework, then they're not going to be eligible for the leave benefits.
Okay. Next question. A lot of the companies on this call are steel distributors and aluminum and stainless distributors. So if those companies are supplying product to a manufacturer who is a larger company that has been deemed essential, would that also cascade down and make the metals distributor an essential business?
So the CISA guidance for the critical manufacturing sector lists that that certain manufacturing aspects are essential. So aluminum and alumina production and processing is one of those industries that's deemed essential. Yeah, and in a lot of cases, a lot of sort of so in that case, and again, you have to go to the state quarantine order to see how it's being applied. But in a lot of those cases, there's a direct connection between, manufacturing aspects that were directly responsible for supplying, key aspects of that manufacturing component to it. Then under the CISA guidance, I believe you would be deemed essential. But again, it does come down to, I think, how your specific operation, what specifically it does. In the CISA guidance, thankfully, it's very kind of broad brushed in how it describes, certain critical industries. And it does that deliberately, I think, to try to capture as much as it can, rather than going into the nitty gritty of, this specific operation is deemed essential and that specific operation is deemed not essential. So what I would encourage them to do, so going back to the original question, the aspect of aluminum and alumina production are deemed essential. I think that covers a lot of the various aspects of that production. So it's not just specifically the plant, but other components that are responsible for making that actual production itself. But again, kind of look at the guidance and then look at how the state applies that guidance. Does that answer the question?
I think so, but there's a lot more, so I'm just going to keep moving along.
Okay.
You guys just noted that a foreign large company with U.S. employers could qualify for PPP. Here's kind of the flip side of that. If a U.S. business with less than 500 U.S. employees has more than 500 total global employees, will they still qualify for PPP?
Yeah, I believe that they would, because it's based on like payments to individuals who are based overseas are not counted under this. So I believe if you've got only 500 or fewer here in the U.S., you would still be eligible for that loan.
Okay, thanks. I've got a compound question here, and I just want to make sure that we get all of this in if we can. The first question comes from someone in the audience, and that is, how can I determine if my business is considered essential? But I want to follow that up quickly with, if you guys could describe, what is the best way for businesses to communicate with their state and local governments and get answers to those kind of questions?
So taking the second part first, typically the quarantine order is issued by the governor, but then the governor will designate a specific agency under his or her administration to carry out the order. So whether it's the enforcement of the order, whether it's making findings on whether certain types of businesses are not exempt, so on. So I think what I would encourage you to do, I think the second part of the question is look at the specific state in which that facility or which that operation takes place, and then look at look at that specific order to determine which agency is going to be reviewing any questions or challenges to whether or not that that order applies to that specific operation.
Okay.
What was the first part of the question?
The first part of the question, I need to go find it. I'm sorry about that.
Yeah, sorry.
That's all right. Well, at this point, I've lost it. So I'll find it a little bit later and we'll come back to it. I do have another question though. There are plenty of them queued up. Are you guys hearing anything about the CISA guidance being adopted internationally?
Yes. So the Chamber has been working with various countries, including Mexico, Japan, 2 or 3 other Asian countries, and Canada, where we've been essentially educating them and also helping to sort of broker a conversation between CISA and those governments to talk about why the guidance is important, and also to kind of advocate for the importance of those countries looking to adopt either the CISA guidance or something very, very close to it. Last week, we had a conversation with the Mexican government, with the Mexican embassy. They have been, I think they're beginning to kind of realize that they are, they're going to be next, if I can say it like that. I think they've been, the conversations are still early, but I think that we're optimistic that they're gonna see a lot of value in what CISA put out. And we also think that the conversation we've had with some of the other countries as well, like Japan, for example, those have also been pretty positive. So hopefully you're going to see more and more countries that will be following the CISA guidance, or putting out something very close to their own guidance under, a similar agency under their governments.
Thanks, John. Glenn, I found the first part of the question that I couldn't find a minute ago, and it's simply this: how can I determine if my business is considered essential?
Got it. Okay, and that's looking at the quarantine order in which the business, wherever they're based, and I think that's where the operations are themselves. So obviously if you've got your corporate headquarters are in Iowa, but you've got key manufacturing facilities in Nebraska, those manufacturing facilities are going to follow the Nebraska order as opposed to the Iowa order, for example.
Okay. Here's another question, and it's going to take me a minute to make sure I get this right, but it goes as follows. Banks are interpreting the rules to say 13 CFR 121.103 for rules of affiliation apply. This means foreign affiliated employees count and would make you ineligible for the loan. Where can we find guidance to confirm only U.S. employees apply?
I'm going to have to look at that section. There's specific language in the statute itself about payments to workers based overseas being ineligible. But the fact that they're including overseas employees to get to that 500 count, I'll have to look at that.
Okay, thanks.
I did find out one thing. Sorry, Chris. There was an earlier question about how you determine what your payroll is for purposes of the PPP program and loan forgiveness.
Yes.
And the way they're going to do that is they will look at your average payroll over the last year. So the 1 year period prior to the date of the loan, they'll look at your average payroll, and that's the number that you're going to meet. So let's say you had 10 people on payroll over the last year on average. Just before you applied for the loan, you had to lay off 3 of them. The number they're going to base everything on is that average of 10 over the previous year. So that's where you would get the incentive to bring those 3 back on payroll to be able to qualify for forgiveness. So it's that 1 year window prior to the loan.
Okay, thanks. Is there a protocol for requesting proof from employees that need to take paid FMLA to care for children? If there are 2 parent families, the spouse needs to provide proof of still working?
Yeah, that is a really thorny question. And we've tried to get some guidance from the Department of Labor as to how you're going to document whether somebody really needs to be taking care of their child. It's a very difficult thing to try and do through a guidance document. The department has tried. If you go to the Wage and Hour Division website, again, there's a long list of Q&As as to how to apply this, but there really is not a firm standard to say, okay, I'm telling you that you should be teleworking, you're telling me you can't because you've got to take care of your child. How am I going to prove that you're absolutely required to do it? It's really not entirely clear. All we've got to go on is the limited information that the department has put out about that. I would tend to err on the side of agreeing with the employee that they are needed, but that's just my personal preference, and unfortunately there really is no real firm guideline as to how you determine if somebody really is needed to take care of a child who's home from school. The other question we've asked of the department is to clarify what happens if this goes on for an extended period of time. If you look at school districts around the South, in some cases we're only about 4 weeks away from school being closed, not because of Corona, but school being closed because that's when they close their schools for summer break. So what do we do in that case? In that case, you don't need to take time off because your kid's school is closed. You're taking it for some other reason. Now, you might be able to make an argument that the regular caregiver who might be, a summer school program isn't available, but we need to get a little bit more clarity around that question too.
Okay. Another question, and this is about the phase 3 benefits extended by the federal government. If a company temporarily extends healthcare benefits while employees are on layoff, does that affect the $600 federal benefit?
No. So the $600 is paid by the federal government to anyone who collects even as much as $1 of unemployment in a given week. So that money, and by the way, that $600 is not going to be used for chargeability purposes for determining UI tax rates or anything like that. I know there's some companies that were worried about that aspect of it. But as long as an individual is collecting as little as $1 a week in unemployment benefits, they are eligible for the $600.
Okay, now I have a quick series of more practical questions that are a little bit more forward-looking for both of you, and then we're getting close to wrap-up time. But the first one goes like this. Should we be concerned that the $350 billion PPP will quickly be exhausted? What happens after that?
Yeah, that question has come up. There was an article in the Wall Street Journal about it today. It is, according to the bill, that is the amount of money that's been made available for these loans. And it is conceivable that banks will lend all of it and it will run out. I'm going to presume that if that were to happen, Congress will provide more money for the program. They're right now, well, Congress is out of session at the moment, but they are already starting to talk about a phase 4 bill, which would include any number of different provisions. It's all kind of being speculated about right now, but my gut would be that if the SBA lenders actually use up the entire allotted amount of $349 billion in Paycheck protection loans, Congress will provide more.
Okay, thanks, Glenn. Next question. There are problems getting through on the websites and the phones to lenders in the SBA. Confusion at banks with underwriting not being well-defined. What's happening to streamline and clarify the process with lenders so that companies can access the funding included in the CARE Act?
Yeah, really good question, and an understandable one too. As I said at the outset of this whole thing, Congress is not in the habit of writing 800 to 900 page bills in less than a week. Neither are banks used to making $350 billion in SBA loans available within a week. And so some of what we're seeing is just the natural hiccups within a system that was not designed to handle this volume all at once. And so we know the SBA is working as hard as they can to get this clarified and streamlined. We know the banks are attempting to interpret the statute as best they can and to get the money out on the street as fast as they can. It's probably not a very satisfactory answer, but it's the honest one, which is the system wasn't designed for this, and they're trying to get it running as smoothly as they can, as fast as they can.
Okay, thank you. And this is going to be our last question, and it'll then be time to wrap up. While the SBA Paycheck Protection Program was launched last week, details on the Economic Stabilization Act program to provide loans to companies with 500 to 10,000 employees have still not been released. When will this happen? What can companies do now to prepare for that guidance?
I'm not sure there's any specific thing to do other than to monitor the Treasury's website on a regular basis to see if that comes to be. Key language in that section of the CARES Act says that the Department of the Treasury will endeavor to set up that loan facility. In other words, they don't have to. It is an option for the Treasury Department to set up that loan facility, and I'm not convinced that they will. And part of a big reason I say that is that if you look at the conditions that Congress stuck into the law under that loan facility, so any company that, let's say this loan facility is set up, any company that avails themselves of it has to abide by a number of very specific conditions, two of which are related to organized labor. Number one, you would have to agree not to change any terms of a collective bargaining agreement for 2 years, and you would have to agree to remain neutral in any organizing drive during the life of a loan you might get from that facility. The fact that Republicans and the Treasury Secretary agreed to put those conditions on those loans, and the introductory paragraph to that section says Treasury shall endeavor to provide, tells me that Treasury may not actually get around to setting that facility up, that it was not something of particular interest to them. So I don't know that we'll see that facility up and running. We might, I could be wrong, but that's my hunch, is that that is not a facility that's going to get a lot of traction at this point anyway.
Okay, thanks, Glenn. And with that, I think we'll wrap up. I want to thank both Glenn and John for presenting on today's webinar. It's been very helpful. If anyone in the audience has any further questions, and we do have some follow-up, please contact Ann DeRazio at MSCI. And once you leave today's webinar, you will be receiving the slides in an email, probably today and possibly tomorrow morning, but we will distribute the slides. So on behalf of MSCI and the U.S. Chamber of Commerce, thanks everyone for joining the webinar. Be safe and well, and I'll leave the last slide up on the screen for a few minutes, which gives you some places to go on the web. Some of them are managed by the U.S. Chamber of Commerce and by MSCI so that you can get some further information. Be safe and be well, everyone. Thanks.